By the year 2030, every baby boomer in America is going to be at least 65 years old. And so they're calling this the silver tsunami. This is where we're going to see a massive increase in everything from the amount of properties that come on the market down into healthcare costs and everything like that. And so understanding how to protect your loved ones as they go into their golden years is going to be super important. So in this interview, we're talking to Bobbi Meloro from Meloro Law Group, where we are really focusing on everything from like what happens if a loved one gets taken advantage of down into preparing for the healthcare costs that come with longer lifespans and long-term care planning. So let's dive in. Bobbi, we're so grateful to have you today. And if you could just tell our listeners a little bit about yourself and how you got into estate planning, that would be amazing.
Thank you so much for having me, Alexa. It's my pleasure to be here. I am happy to talk through some of these issues with you. Education is so important. Education is power, knowledge is power, and we want to be able to be empowered to be able to help our loved ones when whatever situation they might be facing as they age. So I've been practicing law for 25, almost 25 years now. I graduated Law School in 1999. I began my career as a trial attorney. I worked for 8 years for a firm in Miami doing trial work. And then my parents started getting older. My mom is 86 now. She'll turn 87 in February pretty soon, and she's doing great. My dad recently passed away, and just kind of dealing with those issues with my parents as they came up, I realized how difficult it is to navigate it all. There's all kinds of government benefits available to them and things to help them as they age that people don't know about. And as I was working through it with them, I'm thinking, how do seniors who don't have a daughter for a lawyer handle this? How do seniors who don't have children handle this? I just saw that there was a tremendous need there, and I completely transitioned my practice to work with seniors and those with special needs. It is so fulfilling. I absolutely love it. I love talking to people and letting them know the things that they should think about. So, I've been doing that ever since and opened my own practice here in Plantation. I live in Plantation as well, and very involved in my local and legal communities too. So.
Beautiful. It's interesting because it seems as though elder law has not really been a conversation up until, at least that I was aware of, up until recently. And so a lot of attorneys that I've talked to have even said that they don't know a whole lot of attorneys that specialize in that space. And I think as America is aging and we talk about, the silver tsunami and the boomer population turning 65 in the year 2030, there's going to be an increasing need. And especially as we're living longer, your senior years is no longer just, a decade or so. We're talking for some people is 30 or 40 years from 65 until 100 or greater. And so I'm grateful that we have relationships with attorneys like you who do serve this community. Let's start from you're turning 65 and you're like, okay, well, now I'm a senior, right? What are the first things that someone who is now coming into this sort of golden era of their life should be thinking about?
Yeah, well, that's very true, Alexa. The practice of elder law has only been around for about 20 years. It's a relatively new practice area. The demographics are definitely there, definitely support it. There's a huge need out there. This niche is underserved, and so that's part of the reason that I got into it. But when you are turning 65, so any adult over 18 should have some basic estate planning in place, right? No matter people think, oh, I don't have an estate. They think they have to be super wealthy or have land or something to have an estate. That's not the case at all. There's just some basic steps that everyone should take once they're an adult, but especially for those over 65, because what we as elder law attorneys the difference between an estate planning attorney and an elder law attorney is our focus on long-term care planning, right? So when people start to age, you turn 65, you want to make sure your estate is set up in a way to address your long-term care needs as you age. You want to make sure most people think there's a huge misconception out there. People think they need a will, right? A will is my most important document. I need to have a will. In my view, as an estate planning attorney, that's your least important document, obviously, because that just addresses what's going to happen to my stuff after I pass away. We focus on what's going to happen to you while you're still living as you age if you get sick. You want to make sure you have a durable power of attorney in place, healthcare advance directives. Those two documents address your needs while you're still living. If you get sick, you name somebody that you trust to make financial decisions for you, medical decisions for you, and to manage your affairs if and when the time comes, and to be able to apply for these government benefits that I mentioned on your behalf if there's some kind of crisis or emergency or serious illness or hospitalization.
So I think one of the things that is so interesting and is, I'm sure you see it too, like people don't like to talk about estate planning. They don't like to talk about these sort of topics, even though they're super important. I was recently reading an article that talked about how 10% of our senior population will experience dementia or some form of memory loss. And so when we're talking about this long-term care planning, this is probably one of the hardest conversations to have and to think about, because we think of serious illness as, okay, what if I'm in a car accident and I turn into a vegetable type of situation? But really this conversation about what happens if my memory starts to go, that we really need to be focusing on. And so is there anything in terms of documentation or anything that you're seeing in these conversations in relation to that aspect of it?
Yeah, that's a great point. And that just highlights the importance of those two documents I discussed, the durable power of attorney and the healthcare directives, because you need to get those in place while you're healthy, while you're able to do it, while you have capacity, while you have all your mental faculties and your wits about you. Because if you don't, let's say you never put that in place, and people procrastinate all the time. And I understand it's not something that's fun to do. People get a little nervous about it. We really do try to make it easy and fun, kind of, but we try to make it as easy as possible and just try to talk these different scenarios through. People think they have to have so many decisions made and everything done in advance and get overwhelmed, when that's not the case. Let's just start small. Let's just start with these two most important documents. Who do you trust? Who do you want to take care of your finances? Who do you trust? Who do you want to take care of your medical? And then we can just build from there. But if you don't have those in place, your family will have a very difficult time helping you. They won't be able to help you. Their hands will be tied, right? You've made these phone calls, Alexa. You try to call Comcast, and if you share an account with somebody else and your name is not the one on the statement, they won't even talk to you. Oh, put so-and-so on the phone. This is not your account. You're not an authorized person. We can't talk to you. If you need somebody to make phone calls for you, sign paperwork for you, fill papers out, they can't. They have no legal authority to do it unless you give them the written permission. And we do that through the durable power of attorney and the healthcare directives. And if you don't have those in place and you're suffering from dementia, you have memory loss, you are not really capable of making those decisions anymore, then you can no longer, you have to have legal capacity to be able to enter into a power of attorney or healthcare directives. If you don't anymore, you can't sign them. They're not available to you. You've just taken away the two most important tools for your family. Now what they have to do, worst case scenario, they have to go to court. They have to get appointed as your legal guardian. They have to ask the judge to A, declare you to be incapacitated and incapable of making your own decisions, and B, appoint them to do it for you. They are treated like a criminal. They have to get fingerprinted. They have to get background checked. They have to report to the court annually about every dime that was spent for you, about all of your living arrangements and how you're being taken care of. It is a huge burden for your family, and it's extremely costly. So that's the problem. If you don't do your planning and you have an issue like a dementia or an Alzheimer's or a memory loss, because now you can't do your planning. It's too late. You've lost your window of opportunity. So super important to do those things while you're healthy. Young people put it off. Oh, I'm going to do it later. I'm fine. I don't need it. And all of a sudden it's too late.
A lot of our clients are like, I don't want to talk about that. When we sell property, we get to closing, and if they're selling, in a lot of cases, they walk away with a pretty substantial amount of income. And every single time I encourage them to get their estate planning in place. Typically, it's an immediate kind of not necessarily verbally, but you can see their body sort of tense up. And so I think, especially as we're talking about the senior population, generationally, what I've seen, and maybe you can kind of confirm, or maybe you've seen differently, that for specifically the senior population, it's very impolite to talk about money. And so, as the child or the grandchild of someone who is listening to this and they're like, okay, I know that I need to put this in place for my loved one, my parent, my grandparent, and aunt, uncle, whatever it is. How do you sort of initiate that conversation in a way that's not going to immediately get shut down and make them actually want to have this conversation?
Yeah, that's tricky for sure. It's scary for people. People don't want to think about getting sick. They don't want to think about getting older and needing help. Nobody, everyone wants to be so independent. Nobody wants to need help. The way that we address it is we do, like I said, we try to keep it light. We're not talking about gloom and doom and dying and death and illness. We're just talking about getting your ducks in a row. That's what we call it. Let's just get your ducks in a row, make sure that we have everything we need in case there's an emergency. And instead of talking about death and illness and long-term issues, let's just get your ducks in a row, make sure we have what we need if there's an emergency. The biggest thing that I try to tell the people that do come to me and are ready to do this is it's a gift that you're giving to your loved ones. You're at the point where that's all needed. You're no longer the issue. The issue is, what do your kids have to do to be able to help you? Is it going to be super easy for them because they have all the documents they need and you've gotten your ducks in a row? Or are you going to make them go to court? Are you going to make them become your guardian? Are you going to make them be fingerprinted and background checked and things like that? So it's a gift that you give to your children and your loved ones. Some people don't have children.
Okay, so definitely just staying consistent with the conversation, and I think having the compassion and understanding that like these are hard conversations even though they need to be had. Moving away from sort of the kind of emergency type of situation, aging is inevitable. Aging is a privilege that not all of us get to enjoy, and yet as we age, in those cases where you can't take care of yourself anymore and it becomes like not a possibility for your children or your loved ones to physically take care of you. And we know that there's a shortage of kind of reserves in terms of retirement planning and things like that. Can you talk us through a little bit about some of the options or some of the things that people should be preparing for and thinking about, specifically on that long-term care side of it?
Yeah, for sure. First of all, long-term care is extremely costly.
Oh,
Okay.
yes.
If you, some people, there's three ways to pay for it. The cost ranges from, if you're in your own home or in an assisted living residence, on the low end, you're looking at $4,000 a month. On the high end, if you need even more care, 24/7 skilled nursing type care, you're looking at $12,000 a month. So it's extremely costly. If you have, and you don't want to burn through your life savings at such a rapid rate, there's government assistance available to help you cover a portion of that cost. It's called the Medicaid Long-Term Care Program. Elder law attorneys like me are very familiar with it. We know the Medicaid rules very well. We can help you qualify and we can help you get it. It's a very hard benefit to get. They make you jump through lots of hoops, and it's based on financial need. So they look at income, they look at assets. We can structure your income and your assets in such a way to help you qualify for the program. And you can save anywhere from the $23,000 a year in the assisted living or home care context to $84,000 a year in the nursing home context. So that's really going to stretch out your life savings and help it to last longer. And so that's a main focus of our practice, is helping people qualify for and obtain this Medicaid long-term care benefit.
Dementia and had to go through all of this where they didn't really have any estate planning documents in place. The family was taking care of her and that became too much. And so there was this constant like having to lock the bathrooms because she was playing in the bathroom, having to make sure that the doors are locked because they would find her wandering the streets and not being able to find her way back. And so they ended up having to put her in a care facility when that was something that she never wanted to do, they never wanted to do, and it just became unreasonable for them to be able to take care of her. And so I think we think about, these are the things I would want, these are the things that sort of in an ideal situation, and yet as things progress, they don't always work out the way that you want them to. And so to your point, I think being able to say, okay, well, like let's keep it light, but also at some point we have to talk about the worst case scenario and have experts like yourself who know how to handle those things so that you can get them taken care of. Is there a couple of maybe mistakes or sort of themes that you've seen over and over again that families make when they come to you and you're like, okay, maybe if we had done this a little bit differently, like we could have planned better?
Yeah, for sure. Those are great observations, Alexa. At some point, no matter how much everybody wants it, the senior and the family too, at some point, it's not safe to live at home anymore. And you just have to come to that real, you're not doing anybody any favors keeping them home if they're going to wander off into the street and get hurt, if they're going to have an accident or fall or something like that. So you do have to be realistic. As much as everybody wants to keep somebody home, sometimes it's not the best scenario. And so that's when we look at memory care, assisted living, nursing homes. So a couple of mistakes that people make, that sometimes they come to me after they've done some things that they shouldn't have done. So the certain rules of Medicaid apply. One, you cannot give your money away, right? Some people will just take their name off of an account. Okay, let's take mom's name off this account. Now this is not her asset anymore. And there was $50,000 in the account, let's say. Well, Medicaid sees that as a gift. They see that, and they look back a period of 5 years. So don't be giving any, there's always a solution. We just want to do it within what the Medicaid rules allow. You don't want to give gifts. Deeds to properties, that people mess these up all the time, Alexa. They will quit claim deed it to a relative or something. Not that's seen as a gift by Medicaid too. You can't give your property, your real estate away. So you always work with a professional when doing real estate transactions, even if it's between family members. A homestead is exempt. It's not even counted as an asset. So you don't have to transfer your homestead to somebody. And if you need funds to continue to support your expenses, your monthly living expenses, you can sell the home. But if you do, we have to shelter the proceeds. Get me involved in that. You want to list your home for sale? Fine, no problem. Have me involved so that we know what we're going to do with that money after the home sells. Also, there is a wait list involved for people who want to either continue to live at home or live in an assisted living facility. That's one type of Medicaid program. That's called the community-based program. The other type is the nursing home scenario. That's an institutional care program. But for the first program, for the at-home or the assisted living, there's a wait list. They will do a screening with somebody to decide what their priority is on this wait list. We help with that. Consult an attorney first before you go through that screening, because a lot of times you're just super unprepared. You don't answer the questions correctly. And as a result, you're just way down on that waiting list, and you don't want that. It could be forever. Get an attorney's help before you tackle the wait list, and if you're going to move, if you have a plan to move into an assisted living facility, get on the wait list before you do that, because once you're in an assisted living facility, that immediately puts you down further on the wait list, because they feel like you're in a safe environment now. You should always start the wait list process first. So those are my tips.
All great things to know. And what I love about this kind of mindset that you're going into this with is it truly is about dealing with not just a professional, because I think yes, professionals are important, but experts in a specific type of profession that we're talking about. We're not just talking about estate planning, we're talking about elder law, which is, to your point, an additional section of the law, dealing with an agent who understands dealing with the sort of elder community, understands the probate process, understands trust administration, dealing with an accountant who understands taxes when it comes to the transfer of an estate and things like of that nature, where it's not just I have an attorney. So with that in mind, Bobbi, I think we would be remiss if we didn't highlight the importance of the differences between estate planning law and elder law, and why your estate planning attorney may not have the expertise to be able to sort of cover all of the things that come up in elder law. Your expertise that you've shown us already has given us a little sneak peek here, but I think there's probably a lot more to it that we're not even aware of.
Yeah, estate planning attorneys do certain things very well. If you're a young family, if you're just having children, you want a certain type of estate plan. Your needs are different when you're in that phase of your life. When you're in your golden years, when you're in the 65 plus phase of your life, your estate planning needs change. Now you want to focus on your long-term care needs. You're not so much worried about taking care of minor children anymore because your children are grown if you've had them. So you're concerned about taking care of yourself as you age and your long-term care needs. And that's where the elder law attorney comes in, because we have, specialized knowledge about long-term care issues. The durable power of attorney document I mentioned, it's not a boilerplate thing. They're not all created equal. You can get a durable power of attorney on LegalZoom. That's a page, and it is not going to help you when it comes to long-term care planning and Medicaid planning. People come into my office all the time. I say, okay, do you have a durable power of attorney? Oh, sure. Here you go. And it's useless. In order for that power of attorney to work for Medicaid planning and long-term care planning, it has to contain specific authority for your loved ones to do things for you, to qualify you for Medicaid, to shelter income, to shelter assets, to set up a special needs trust or a qualified income trust, or all these strategies and tools that we use to qualify you for Medicaid have to be laid out in that durable power of attorney document for it to work. Selling real estate, if you don't have that listed in your durable power of attorney document and your loved one has to sell your home, Alexa's going to have trouble. Alexa's hands are going to be tied too. She might need to tell you need a guardian appointed because your loved one never authorized you and now is incapable of doing it. And that's going to postpone the sale of the home immensely. Just the documents are different. Your needs are different when you're a young person versus when you're an older person. That's the key difference, I think.
Definitely. Just to expand on the real estate side of things, a lot of agents will tell you that you can sell property if you have documentation that shows, okay, I have power of attorney, but again, to your point, if it's not specifically written, the agent will take the listing. But what will happen is once you sign a contract with that buyer, it goes over to the title company, and the title company starts reviewing all of the closing documents. And they're like, hey, by the way, you can't sell this property. And you've gone through this entire process of putting a property on the market, marketing it, getting a buyer who wants to purchase the property. And now you have to go all the way back to square one. And it truly throws off people's timelines and makes things really complicated when, had you dealt with experts from the beginning, you could have saved yourself a lot of time and frustration. And I think that's one of the things that on the real estate side, we see a lot. The other thing that we see a lot is when family members or our seniors are like, oh, my kids will take care of it. And they don't explicitly sort of name one person to be responsible for it. And so you end up in this situation where you have multiple siblings who don't live in the same place or don't take on the same level of responsibility and can't agree on anything. And in a lot of cases, it comes down to fighting over the fact that one of the kids has sentimental attachment to a property, one of them wants to protect their inheritance, and the other one is trying to pay for the care of the senior. And so there's this sort of butting of heads between loved ones who all have great intentions and yet can't agree on anything. And so is there any sort of advice that you would give to maybe the child who's in the situation, or even to the parent who has multiple children and is thinking, my kids will figure it out, don't worry about it?
Yeah, never a good idea. I try to counsel people. People do come to me when we sit down and we say, okay, who do you want to take care of this? And who do you want to take care of that? They want to have all their kids act together. I try to dissuade them from that. I explain the pros and cons of it. On the one hand, yes, okay, you're making them all feel important and that you love them all equally and you want them to all be involved in the decisions, but you might be doing them and yourself a disservice in the end because of the delay that's often involved with multiple people. Just as you pointed out, they might live in different areas, they might have different goals, they might just not be accessible or not be organized or not be able to do it. So I always recommend that they have one primary child or loved one be the designated person, and then they can name all the other kids as backups if they want to make sure that they're named in the documents and feel that they can play a role if needed. But it's much easier for everyone involved if you have the one primary. And I say, okay, which one do you think would be better managing money? Okay, let's pick that person to be your financial power of attorney. And then who would be better with medical? Oh, my niece is a nurse. Great, perfect. Let's name your niece as because you not only want to name somebody that you love, you want to name somebody that would know what they're doing, and would be able to do it in the right way. So somebody that's good with numbers or money for the financial, somebody that knows the healthcare field for the healthcare is ideal if you have that in your family. So yeah, try not to name multiple because it can just result in delay. It might eventually get done. It will just be harder for everybody when you need
Absolutely.
multiple signatures and have to track people down.
And I think the same thing goes for the probate process. It goes for just in your estate plans in general. A lot of times, the hardest part of the probate process, specifically when you're selling
Mhm.
property, is figuring out who the personal representative is. And to your point earlier, having to go through the whole court system and just the responsibilities that you put on that person is it really becomes a burden. And we think about in specifically in probate and administration, we think about how people are going to handle things when they're in their best version of themselves, and we forget to think about how people handle stuff in grief. Can you sort of speak to any kind of advice that you would give to just making sure that power is not abused, or power is actually, I don't want to say enforced, is
Mhm.
executed the way that it was intended?
Mhm. Sure. That's, well, the primary goal with estate planning, whether it be when you're younger or older, is to avoid probate, to have to avoid appointing a personal representative and have to
Absolutely.
avoid probate altogether. The way we do that is by making sure there's beneficiaries named on everything, including the deed to your home. And you have a couple of options when it comes to the deed to your home. You could deed it into a trust, which is an entity which never dies. And then the trustee, whoever, it's you while you're still living, and then you name somebody as successor trustee to take over after you pass away or if you get sick. The trustee manages the home. The home is owned by the trust. If anything happens to you, the trustee can sell it very easily. No court involved, no personal representative involved, no probate involved. If the other option is called an enhanced life estate deed, where you can, instead of deeding it to a trust, you would still have it in your individual name, but you can name beneficiaries directly on your deed. I own this home for as long as I live. If and when I die, I want it to go to Jane, Susie, and Bill. And their names are right on it. It passes to them after you die, and they can step in and sell it as needed or do whatever needs to be done. If you own a home in your individual name, I, Bobbi Meloro, own this home. If I die, it's going through probate. No matter what my will says, no matter what my trust says, it all goes by what the deed says. It will be more difficult to sell, and it will take longer to sell because you have to first get court approval for everything. So naming beneficiaries on everything to avoid probate is super, super important. That way you don't have to, burden a loved one to be your personal representative. A personal representative gets the job of going to court, filing a probate for you, notifying your creditors, opening your mail, dealing with so many things when they may have their own family responsibilities or jobs. We really don't want to have to rely on a personal representative. We want to make it as easy as possible for our family. So name beneficiaries on everything would be my advice there. But your beneficiary that you do name, bank accounts, retirement accounts, life insurance, deed to your home, all of those things should have beneficiaries named. The caveat is that you could use a trust, and the trust could be beneficiary on everything. That's the safest route because a trust never dies. There's always a trustee that can step in. If you decide to name individuals as beneficiaries instead, oh no, I just want to name my kids as my beneficiaries, not a trust. I don't want to deal with a trust. That's okay too. But the caveat with that is that person or the people that you name have to be over 18. Minors cannot inherit property under Florida law without a guardian. So you're still having to go to court, and they have to be alive. They have to outlive you. If somebody dies before you that you've named as a beneficiary, it's going to probate because they don't have anybody to give it to. So that's the best. My advice is avoid naming a personal representative, avoid probate,
Yes.
and just name beneficiaries on everything.
We deal with a lot of cases where people have a trust and they're like, "Oh, we're good," and they bring out the trust documents, and the property is in the individual's name, so the trust wasn't properly funded. We also have dealt with in a lot of cases where there's a trust in place, but to that same point, they didn't put any of the properties in the trust, or they have it in a different LLC, and then they lived in one state. They have an LLC that's owned by the trust in, let's say, Virginia, but the Florida property they didn't properly fund either, and so they actually end up having to go through probate in both places. And so it gets really messy when, again, you're buying property or you're selling property and haven't included the experts that are going to help you accomplish your goals. And so I cannot stress enough to anyone who's listening to this,
Yeah.
deal with experts. If you're thinking about legacy and you're thinking about what you're going to leave behind, I get it. There's 90,000 real estate agents in South Florida, like just between Broward, Dade, and Palm Beach. We have the largest MLS association in the entire country. And so it's very easy to be like, oh, my friend has it. But when you're not factoring in an elder law attorney like Bobbi, you're not dealing with an accountant that knows how to handle these things, you're not dealing with an agent that specializes in this place, you end up sort of with all these unintended consequences just because we didn't ask the right questions. So with that in mind, Bobbi, we're running up on time. Is there anything else that you would want to leave our listeners with today that is going to be like that mic drop that they're like, oh man, I really need to talk to Bobbi?
I appreciate your observation about that. Just having a trust isn't really the answer. You actually have to know how it works and
Yes.
make sure you title things into it. And that's where working with an attorney is helpful, because they can explain that process to you, explain all these steps that you have to take so that you don't have this false sense of security. Oh, I created a trust, I'm good. We have to make sure that all the steps are followed and that you really, everything is truly set up the way you want it to be. So I would just leave it with, now's the time. Now's the time to take action, get your ducks in a row, just do one small thing, one small step toward getting your affairs in order and making sure you've got everything set up in case there's an emergency so that so that your loved ones can step in and it can be as easy as possible for them, because it's a lot for them to deal with. So let's make it easy for them. Let's get your ducks in a row. Don't procrastinate.
I love it. So after listening to this, I'm sure there's going to be a couple of people who are like, I need to have a conversation with Bobbi. So how would they go about finding you?
Sure. We have a website. My firm is called Meloro Law. So you can find me on my website. All of our contact information is there. Our phone number is 954-577-1010, and or by email at Bobbi, B-O-B-I, at melorolaw.com.
Beautiful. Thank you, Bobbi. This was amazing.
Thank you,
And thank you
Alexa.
so
Such a
much
pleasure.
for joining us today. This was amazing.
Thanks for having me. I enjoyed it thoroughly.